So good afternoon, everyone. It's 1:30 on Monday, the 11th of January, and time to open this preliminary session. Can I first check that everyone can hear me by asking you to wave your hand? That's great, thanks. So welcome to the inquiry in relation to the application by Scottish Power Renewables for consent under Section 36 of the Electricity Act 1989 and/or a direction under Section 57 of the Town and Country Planning Scotland Act 1997 for the construction and operation of a 13-turbine extension to the existing Arecleoch wind farm, approximately 3 kilometres southwest of Bar Hill in South Ayrshire. We will refer to the proposal as the Arecleoch extension during proceedings. My name's Alison Kirkwood, and I'm joined by my colleague David Liddle, who maybe give a wave. We are reporters with the Scottish Government's Planning and Environmental Appeals Division. And we've been jointly appointed by Scottish ministers to consider this application and report our findings and recommendations to them. As a result of objections to the application from South Ayrshire Council and others, Scottish ministers decided that an inquiry should be held into the proposal. The inquiry will take the form of a number of oral sessions using both formal inquiry and more informal hearing procedures. The main purpose of the inquiry is to make sure we understand the positions of parties on each of the specific topics where further evidence was considered necessary. Where there is a dispute between parties, we need to be clear on the reasons for that dispute. This is so that these matters can be clearly set out in our report to ministers. Can I firstly ask participants to introduce themselves? Some of you haven't been at one of our sessions before. Starting with the applicant, Mr. Innes.
Hello, good afternoon. Thank you, madam. My name is Colin Innes, and I'm a partner in the law firm of Shepherd and Wedderburn, and appear this afternoon on behalf of the applicants. I do have some further information about who will be representing the applicants at other hearings, but perhaps just you'll probably just be wanting to do the introductions at this stage. So I'll leave it there at the moment. Thank you.
Lovely, thank you. Yes, we'll go through each of the sessions. South Ayrshire Council, Mr. Campbell. You're still on mute, Mr. Campbell.
Start again. Good afternoon.
Yes,
good afternoon.
Lovely.
I am John Campbell. I'm a Queen's Counsel at the Scottish Bar, and I represent South Ayrshire Council in this examination, instructed by South Ayrshire Council's legal department. I'm accompanied this afternoon by Mr. Alistair McGibbon, a planning officer who has, in the middle of the screen, I think. You could give a wave, Alistair, please. Thank you. Thank you, ma'am.
Lovely, thank you. New Luce Community Council.
Hello, can you all hear me? Yeah, I'm Alistair Buckoak from New Luce Community Council, and I live in New Luce. I don't live in Bar Hill or that area. Okay.
Lovely, thank you. Bardrocket and Knockdoylin Estates.
Thank you, ma'am. Ian Kelly, the planning consultant representing the two estates. It will only be myself participating in the call today. Thank you.
Thanks. And now on to the individual participants. Ms. Crosswaite, would you like to go first?
Yes, I'm Susan Crosswaite, and I'm a public objector, and I'm representing members.
Would you like to introduce the other, your witnesses that are on the call as well? Ms. Crosswaite, are you able to introduce your witnesses that are here?
Yes. My private water supply witness is Dr. Rachel Connor, who is. Yes, can you hear me?
Thank you. We can, yes. So,
Hello.
Dr. Connor.
Hello, yes, I'm Dr. Rachel. And I'm representing the matter of private water supplies.
Okay, thank you. Any others, Miss Crosswaite? See, you've got other. I think you're on mute at the minute.
Is that better? Can you hear me?
Can hear you now. Yes, thanks.
Sorry, it seemed to be coming in.
If Mr. Grosvenor could just give a wave, then we lovely. Anyone else? Miss McDade was here earlier.
Okay.
That's fine. I think it's just to make sure that people knew who was on the screen. So we've got Mr. Grosvenor. The note from Mr. Gibbons saying the sound's really breaking up. Is that from myself or from Miss Crosswaite?
Sorry, that is from Miss Crosswaite. I've had other people in the council have said they've had problems with this system in the past, so I don't know if it maybe some people might have problems with, but certainly you can hear yourself very clearly.
Right. I say we'll keep it under review, and our IT support are here, and we have potential other systems if need be. Yes, David.
I was having the same problems as Mr. McGibbon there. It might be, Ms. Cottery, as we go on, that in other cases, turning your video off and just keeping your sound on has sometimes helped, and it might, if the problem was just bandwidth at your end. But maybe we can see how we go on and try that if the problem persists.
Yeah, I think the good thing about having the preliminary meeting today, it allows us to sort of identify any problems and come up with solutions before we start the sessions proper. Okay, I'll proceed on.
Sorry, can I ask? Can people see me? I can't see myself now. And you didn't seem to see me there, so I'm just checking that I am in fact still connected.
I can't see your face now, Miss McDade, but I can hear you. So it's maybe just your video seems to have switched off.
Okay.
Yep. Oh, you're back.
Okay, that's fine. Thank you.
Okay, and you're another of Miss Crosswaite's witnesses for other parties who aren't familiar.
Yes.
Thank you. Mr. Stevenson. Getting your mute button. Down at the bottom of the screen, or sometimes if you hit the space bar, it helps.
Yeah, that's right. Struns and an objector.
Thank you. And Ms. Ellis.
Hello, I'm Harriet Ellis, other objector representing just myself.
Thank you. And Ms. Spence.
Hello, I'm representing also giving evidence from the Bar Hill Community Council.
Okay, thank you very much for the introductions. So the only person I think we're missing is Mr. Andrews. but he will be able to watch the introductory session on the library, DPA library. I noticed some breakup with some of the sound there as well, so we will keep that under review. But for the majority of the session, I'll be speaking, so we'll proceed on that basis as long as you can hear me loud and clearly. But please let me know if my sound's breaking up, and we'll get in touch with our IT support and see if we can improve things. Is that okay to proceed? Okay, so we held 2 pre-examination meetings in advance of the inquiry to guide the procedures for the case, one in September and one in November, and these can be viewed on the DPA webcast library. David and I have visited the site, a number of viewpoints and places of interest on 2 separate occasions in September and early November. These visits took place on an unaccompanied basis. We may need to make further unaccompanied visits prior to completing our report, and also arrangements will be made for a series of accompanied visits to specific locations relating to noise monitoring once travel restrictions allow. We had hoped to have these arrangements in place already, but we obviously need to wait and see when we're able to travel again, but we'll get those arranged in due course. This inquiry will be webcast live at www.dpa.public-i.tv, and I think a link to that is provided each day for you. The video recording of the inquiry will be retained on the website after the application is determined. By taking part in the virtual inquiry, you're consenting to being filmed and to the use and storage of these images and sound recordings and any information contained in them for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. For the benefit of those watching who haven't been involved to date, I will briefly explain the process that will be followed in this virtual inquiry. This is the 3rd wind farm case under Section 36 of the Electricity Act that we have conducted using virtual proceedings in response to the COVID-19 pandemic. And lessons learned from the previous inquiries have helped shape the arrangements for this inquiry. During the current period of restrictions, the Council is not required to place paper copies of documents for the case on deposit. The documents have been published on the DPA website under the case reference WIN-370-2. The inquiry will be conducted in 2 parts and cover a range of topics. A copy of the inquiry programme has been sent to all participants and can be viewed on the DPA website. David and I will both attend all sessions, with one of us leading and the other providing support. Part 1 will commence tomorrow, 12th of January, with a hearing session on policy matters and socio-economic issues. A 2-day formal inquiry on hydrology, including private water supplies, will follow on Wednesday and Thursday. That's the 13th and 14th of January. Friday the 15th we can use as a catch-up day for either of these topics if required. We will then have a 2-week break and commence part 2 of the inquiry on Monday the 1st of February. It's anticipated that landscape and visual impact matters will be considered at a 3-day inquiry running from Monday the 1st to Wednesday the 3rd of February. There will be a hearing session on the morning of Thursday the 4th of February covering ecology, bats in particular, access, traffic and transport, and peatland. These are the topics involving the applicant and Mr. Stevenson. On the afternoon of Thursday the 4th of February, there will be a hearing on an overview of effects and infrastructure implication, and that will involve the applicant, Mr. Andrews and Ms. Spence. The current timetable on our website shows a hearing session for topic 9 SF6 gas on the morning of Friday the 5th of February. Ms. Crosswaite, you've now indicated that you don't intend to give any further evidence on this matter. Is that correct? We will, of course, take account of your submissions to date on this matter. There's a hearing session on conditions currently programmed for the afternoon of Friday, the 5th of February. So we would now intend to bring this forward to the Friday morning, if that is acceptable to parties. This will cover all conditions to be applied if permission is granted, with the exception of noise, which we will deal with separately at the noise inquiry. Now, we currently have the applicant and the council down to attend the session on conditions. Ms. Crosswaite, you submitted detailed comments on the draft conditions. Do you wish to be represented at the hearing session?
Yes, if that's okay.
Yes, that's fine. Are there any other parties who would like to attend the hearing session on conditions?
I think that my witness, Dr. Rachel Connor, might want to attend that too.
Okay, and Ms. Spence, I see you waving your hand. Would you like to attend that too?
I would.
Okay, and does the morning of Friday the 5th acceptable to all parties?
Yeah.
Mr. Campbell's really, I suppose, for yourself, because the applicant and Ms. Crosswaite would have been expecting to be attending the session anyway on that date. Is that okay for the council? Sorry, you'll need to unmute.
Yes, ma'am, of course it is. That's fine.
That's fine, right. Okay, that gives us a longer time to go through the conditions if we need to, rather than just starting at lunchtime. Okay, back to the time. The last topic, noise, is programmed for a 2-day inquiry on Tuesday the 9th and Wednesday the 10th of February. We will endeavour to follow this timetable as closely as possible. However, please note that the programme may be subject to change, whether to accommodate delays or unforeseen circumstances. So we may need a little bit of flexibility. I know Mr. Andrews has joined us. Welcome, Mr. Andrews. Good to see you. Okay, as I've outlined, 3 of the topics will be dealt with using formal inquiry sessions. And for those not familiar with the process, the normal sequence of events is the advocate or solicitor introduces their witness, who gives their evidence in chief. The witnesses have prepared written statements called precognitions in advance. These statements, along with all core documents, are available to view on our website. The witness is then cross-examined by opposing parties. The reporters may then ask any questions of the witness, and then the witness can be asked some further questions by their own advocate or solicitor as re-examination. When the evidence on all topics is concluded, parties will have the opportunity to make a closing submission in writing. The remaining oral sessions will take the form of virtual hearings. These are less formal discussions involving all relevant participants and will be chaired by either David or myself. Now, in addition to the evidence considered through the inquiry and hearing sessions, our report to ministers will also consider a range of other matters raised in consultation responses and written representations which were submitted to the Energy Consents Unit to the original application. The details of all of these can be viewed on the case file on the DPA website. A protocol note for the first week of the inquiry was sent to participants before Christmas. This will be kept under review, and where necessary, changes will be made prior to issuing a further version for the second part of the inquiry, commencing on the 1st of February. So if things haven't worked or aren't working for part 1, we've got the opportunity to tweak things. So we'll keep that under review. The protocol includes matters relating to the arrangements for the virtual sessions to help make these run smoothly. To summarise, for the benefit of those watching, it's anticipated that proceedings will commence each day at 10 a.m. and run until around 4 p.m. 1 hour will be allowed for lunch and regular screen breaks will be taken. Please note that all teams must adhere to all government guidance on COVID-19 when participating. For example, parties should be working from home unless they need to be in the office. Physical distancing must be maintained, no close contact, no sharing of documents, equipment. If any participant is taken ill during or shows sign of COVID-19, the reporters will ensure medical attention is sought. We will consult parties as soon as possible thereafter on how and when to convene the inquiry. If at any point the reporters are in any doubt that the above advice on COVID-19 isn't being followed, it may be necessary to adjourn proceedings. Can I remind all parties that electronic devices should not be audible during the inquiry and hearing sessions? If you have an emergency please don't hesitate to depart, but just ask that we adjourn proceedings. A member of the DPA IT staff will be present during the virtual process to address any technical issues should they arise. Okay, I'm going to go into documents if that's okay. So all parties should now have a memory stick with a finalised set of the core documents that have been submitted up to the 31st of December. Can I check, has everybody received their memory stick that needs it for part 1? Mr. Campbell? Yeah, is that the... Okay, excellent. We would like to thank the DPA case officer team. Sorry, Mr. Campbell.
Yeah, I just want to add that I am having some problems with some of the documentary stick. For whatever reason, there are 1 or 2 of them that aren't opening. I've downloaded these, but as long as everybody else has them, that's fine. I can refer to them.
Okay, well, if you let us know which ones you're going to refer to, then parties can check that they're able to access them. All the documents are on the DPA website as well and are on the hub. So we've really got 3 different places that we can download them from, and that's the benefit of us having the list of documents that you're going to refer to in advance. But thanks for flagging that up. We'd like to thank the DPA case officer team and Emma Payton from Shepherd and Wedderburn for their considerable efforts in making the documents available to all. I think it's been a huge task and we're very, very appreciative. Now, as I say, advance notice is to be given in writing of the main document references for each witness or participant. And can we ask that when you're making that list, you use the CD number at the front of the reference, which allows everybody to find it easily. This must be done before 5 p.m. on the day before the relevant sessions to allow the case officer time to circulate the list to all other parties. Problems arose in previous inquiries where document lists were being circulated late at night, which meant that they couldn't be shared with other parties until the morning of the session. So we'd ask everybody to adhere to the 5 p.m. deadline, which will allow Jane to circulate so everybody knows which documents are going to be used. The landscape and visual impact inquiry session, that starts on a Monday morning. So the list of document references would need to be circulated by 5 p.m. on Friday the 29th of January. Take a note of that. Now, we're aware that there are a small number of documents relevant to part 1 of the inquiry which have been submitted since the 31st of December cut-off date. So they aren't on the memory stick. If you're intending to refer to any of these, can you please make other parties aware that they're not on the memory stick so that they can download them either from the website or from the hub? I say there's only, I think, 3 or 4 documents that refers to. We propose that for all the inquiry sessions, precognitions are taken as read and therefore not read out in full by witnesses. We would ask that cross-examination focuses on the essential matters that are in dispute to keep things as concise and use the time to our best of our abilities. The reporter may intervene if it's considered that we're straying into matters that don't need to be included in our report. And finally, a few housekeeping matters. Parties should use their microphones, making sure to turn off every time you conclude speaking. This is required to allow the recording to switch to the person that's speaking. It's important that those participating, including the reporters, have time to follow the evidence and access any required documents. So there will be pauses while we get the documents, and you will be given time to find the relevant documents that you need to. Just as a normal process, the reporter or opposing sides can intervene by turning their mics on, but any points raised should be addressed to the reporter in the first instance. So the benefit of David and I working together is if one of us is leading, the other can be keeping an eye on people raising their hands and looking to come in. So hopefully, but if we don't see you, just speak out and we can interrupt proceedings. So if you raise your hand in the first instance, and if you're agreeing with the question, a thumbs up would be useful. And as Callum said earlier, if you're not actively participating, you'll have your video switched off as well as your mic. But all other parties, whether if you're not taking part in a session, you can view proceedings live on the DPA website to keep in touch with what's going on. Just want to briefly touch on submissions for part 2 of the inquiry. All additional documents and inquiry reports for the oral sessions in February should now have been submitted. I know that there are still some coming in this morning. If there are any that are still outstanding, can you please submit them as soon as possible? And this will allow them to be uploaded onto the Hub and the DPA website. Can I remind everybody that when you're submitting documents, you need to submit them to all parties. A few have been coming in that have just been sent to Jane, so they need to go to the applicant and all other parties as well. And if you could remember to use the reference numbers as well, following the guidance that was that's been set up on the Hub with your individual number for your documents. Precognitions for the inquiry session on landscape and visual impacts are due on Friday the 15th, and precognitions for the inquiry on noise impact are due on Wednesday the 20th. Those are the only 2 outstanding dates that we still have to reach. An updated set of core documents will be provided on memory sticks prior to the start of part 2 of the inquiry on the 1st of February. Can I suggest a cut-off date of Friday the 22nd for all documents, and the memory sticks to arrive with participants by Thursday the 28th? Is that acceptable to all parties? Is that doable, Emma? Well, you want to comment, Mr. Innes? Is that?
We'll do our very best. As soon as we've got the stuff, we'll do our absolute best to turn it around as quickly as possible, knowing that it's important that everyone gets access to the documents to be able to download from a stick as well as the Hub. So we will do it as quickly as we can.
That's great. And from our point, I mean, we'll go through everything at our end and confirm to Emma and others when they're able to go on. But it certainly seemed to work very well for part 1, albeit with a lot of work from your end. Okay, so before we turn to the details of the hearing and inquiry sessions taking place this week, Any questions on any of the procedural matters I've covered so far? Everybody? Yes, Miss Spence.
Oh, sorry.
Nope, that's I thought you had a question. Well, that's good if everybody's clear. So, in terms of this week's proceedings, the hearing on policy and socio-economic matters will commence at 10 a.m. tomorrow. Please be ready to join the meeting at 9:45. You'll be sent a link in the same way as you were sent for today's proceedings. Now, we're expecting the following participants, so I'll maybe just ask you to confirm for the applicant, Mr. Innes and Ms. Sidgwick. I think you still had your mute on, but if you give me a thumbs up, that.
Yes, it's myself and Ms. Sidgwick tomorrow. Thank you.
Lovely, thank you. And for South Ayrshire Council, Mr. Campbell and Mr. McGibbon.
Yes, ma'am, that's correct.
Thank you. Mr. Bocoke for New Luce Community Council, expecting you tomorrow. Yep, excellent. Mr. Kelly for the estates.
Yes, it'll be myself taking part, but will just be me again tomorrow.
That's lovely, thank you. And Miss McDade for Miss Crosswaite. Miss Crosswaite, are you intending to speak as well, or is it just Miss McDade on your behalf?
It's just Miss McDade on my behalf.
Thank you.
I think Dr. Rachel Connor wanted to say something earlier, but she didn't, so she wasn't noticed.
All right, sorry. Just give me 1 second and I'll finish off with this one. I'll come back to you, Dr. Connor. Mr. Andrews, we're expecting you tomorrow as well. Excellent. Is that everybody that's taking part in tomorrow's hearing? Okay, Dr. Connor.
Yes, thank you. I just wanted to confirm that as we don't have an advocate leading, it will be open to do my examination after cross-examination.
Sorry, Miss Dr. Connor, you're breaking up a wee bit. Could you maybe try and turn your audio off and see if whether we can hear? Turn your video off, sorry. Yeah.
Better? Turn the video off. Can you hear better?
I can, yes.
Hello? Yes.
So you're asking about your leading
wanted...
evidence because you don't have a...
Yes, I just wanted to confirm that because we don't have counsel leading it, whether I can re-examine myself after I've had cross-examination. Hello? Is anybody there?
Yes, sorry, I was just unmuting myself. Yes, I don't have a problem with that. If you're basically acting as your witness and your advocate.
Okay, thank you.
Is that okay with the applicant? Sorry, I can't hear you, Mr. Innes.
Dr. Connor doesn't ask any leading questions in her re-examination. No, I mean, if there's matters she wants to raise afterwards, you know, I can fully appreciate the position that that they're in, and she'd be quite entitled to have some follow-up questions. But equally, it's not an opportunity to go back over new ground that would then open up further questions. It's got to be a matters raised in cross-examination.
Are you happy with that, Dr. Connor?
Yes, I have to say I am not experienced in the techniques, so to speak, and in doing my own re-examination. So if I go wrong, I'm very happy to be corrected.
Okay, that's helpful, and David and I will, if you stray onto the parties, we can step in. That sounds fine. Okay. So back to tomorrow's proceedings. So everyone should have a copy of the hearing agenda and a list of the main documents that the reporter intends to refer to. Now, please remember that a note of the main documents which participants are going to refer to should be sent to the case officer and other participants by 5 o'clock today, if you haven't done so already. I think we got to note, Mr. Bocoke, of the document you wanted to refer to today, but just for other parties, there wasn't a reference on it. So I think that CD 20.16 is the document that Mr. Bocoke is looking.
That's correct. Yes, that's correct.
And I think I asked Jane to circulate. Your email only came in to us, so I think we've sent it to all other parties, or we will this afternoon with a note of that. But if you could just remind everybody, if they're sending their document list, to send it to all participants as well as the case officer.
It wasn't originally, that wasn't completely clear. That was my impression. We had to send it to the DPEA and to the applicant hub, Emma Payton. So I wasn't. I mean, if I'd known that, I would have obviously sent the WE-transfers to everybody.
Right.
So.
That's fine. Apologies if we haven't made it clear. It just speeds things up. It means things don't get stuck with the case officer and delay. Everybody gets the information together. But thank you for sending that in today. Any procedural questions in relation to tomorrow's hearing? It'd be good to get those out of the way today so that we can get started promptly tomorrow. Mr. Campbell.
Yes, ma'am. In the joining instructions which your office sent out, parties for tomorrow are listed 1 to 6. Is that the running order that you intend, or is it simply a convenient list?
Sorry, I can't hear.
Okay, Mr. Campbell was asking about the running order for tomorrow. David, do you want to come in? David's leading tomorrow's hearing.
Yes, thanks. It's just a convenient list. I have to say I don't have a running order as such. You hopefully have seen the agenda and the questions that I have that we have that it foreshadows. So I was planning simply to run through that agenda and give parties the chance to ask our questions, but then come in on additional points if they want. So that's how I was going to run it. Yeah.
Okay, thank you. That's most helpful.
Any other questions for tomorrow, Mr. Ennis?
Yes, I've just got one thing to say, that our participants will be at Scottish Power's headquarters tomorrow, appearing from their training room, which has been fully assessed, and in terms of numbers, all the parties who are present will be more than socially distanced. And the reason for it is we've participated in a number of other hearing sessions and other procedures. And one of the problems is that if you don't have the applicant, it causes problems. So that is why we would prefer to have and are going to somewhere with a firmer grid connection than working at home. And I'm sure I, like many others, will have other demands on our internet. And I have children at home that are studying and are also having to use the internet and bandwidth. So in terms of that, the premises have been fully tested and are fully secure from a COVID perspective, with significant gaps. And the way in which the technology operates is that different participants have different cameras, and that enables complete separation between those appearing. And Ms. Martin, currently on screen, is, I think, sitting in that very room, and that's what it will look like. But it's just to give you the confirmation that it has been fully tested, and that the whole procedure at Scottish Power's HQ, which is providing essential services, is entirely geared up to ensure full compliance with all measures that can be taken in relation to health and safety and COVID measures. but I just wanted to make that clear from the outset. If you
Yeah.
suddenly saw us all appearing and were wondering how far away we are, well, it's all been set up, and as I say, everyone's got an individual camera and separated by some distance. But the difficulty is that we have had prior experience where we have had technology issues, and it does cause an untold problem if the applicant is unable to participate and ends up not being able to effectively work with the process. So I thought I'd let you know that now, rather than us appearing tomorrow morning and you wondering why the background was looking a little different.
Thank you very much for that information and for the assurances on the safety. I suppose what we just ask is that participants aren't sort of communicating, and there have been experiences in the past where people have been in the room, but then parties have come together. But I think people are much more aware now of the social distancing rules. So thank you for that. Anybody else got any comments on tomorrow's proceedings, Ms. Crosswaite?
Yes, although I obviously am not going to be participating in the topic tomorrow, I would like to be able to be present to listen and to watch.
That's fine. You can either, I mean, as an objector, what to do is to, if you sent the link, just log in, but turn your mute audio and sound off, and video and audio off, and that's fine. Otherwise, I mean, you can watch it obviously from the DPA live website, but as an objector, you're perfectly entitled to join and just keep in the background.
Okay, thank you very much. Thank you.
Ms. McDade?
Yeah, just a couple of points. I think Mr. Little answered my question about in your agenda, you sometimes said things like, we'll give Mr. Kelly the opportunity to respond, and I assume that the rest of us equally can come in on those points. Yeah, so David's nodding for that. Thank you. Also, there's one issue which isn't actually mentioned in the agenda, but which is mentioned in Ms. Sidgwick's statement, which I would like to mention, and it follows in logically behind the constraint payments, and that's on the black start. So I don't think that was previously mentioned. So I'm just checking that will be okay to put that in. Yeah.
Yeah, I think that's.
It's not in because I didn't necessarily have any questions about it, but if you want to raise it as an issue for discussion, then of course that's absolutely fine.
Okay, that's great. And I just wondered on point 12, which is about peat, whether there is actually a policy question in there, or whether that logically goes to the peat sessions. So it's a supplementary. It's about differences in peat mapping. Supplementary, it says point 12, supplementary guidance on wind energy, and I didn't think that was a policy point. I certainly haven't looked at this, and I haven't looked at the maps, but I know that peat has been discussed in detail later on. So I just wonder if that point actually is a policy question. I'm just asking because I can look it up if I need to.
Okay,
David, do you want to?
Yeah, I think it's simply there insofar as we wanted. I think a point had been made that I'm struggling to remember. I don't have it right in front of me, but the characterisation of peat in terms of the different levels of protection, if you like, in the spatial framework. I think there was an uncertainty in our minds as to whether the two documents were consistent with each other. So it was just a clarification point. I think this, in our discussions, Alison, this probably came from you. Have I got that right? Apologies. Yeah. I think that was the issue.
Okay, well, I can look at it. And also, can I just mention and apologise? There's 3 numbering mistakes in my statement. I had a confusion with Ms. Crosswaite. So can I just mention them now in case people are looking at them and not knowing what document that is? So paragraph 16 in my hearing statement, which is 23.1, it refers to our REF notes on wind farm constraints, and the numbering is correctly listed in the list as CD 23.5, but I referred to it wrongly as 23.4, so it is 23.5. And also similarly, paragraph 24, wind power in Scotland and the Western Link HVDC cable is correctly CD 2313, not as I have listed it in my hearing statement. And in paragraph 44, it's CD 23.8, not as it says in this statement. So I apologise for those mistakes due to changes between documents.
That's fine. That's helpful. Yeah, I think there were a few issues sort of bringing all Miss Crosswaite's documents together, so I can understand why the sequencing knocked out a bit. And obviously, I think we corrected it after your inquiry report or your hearing statement was submitted. So I think that's where the confusion has arisen. In terms of your question to David, yeah, I think it's really just establishing whether the more up-to-date guidance document from South Ayrshire Council changes anything in relation to the status of the site in terms of the descriptions, but it wasn't intended. I don't think that they would go into any further detail on that. I think you're right that it relates to that would be for the hearing session on Pete. Okay, anything else for tomorrow? If not, I'll just proceed on to the topic 4 inquiry on hydrology and private water supply. That will commence at 10 AM on Wednesday the 13th. Now we agreed that evidence will be given in the following order. So South Ayrshire Council first, who I believe will be represented by Mr. Campbell and Miss Loban. Is that correct, Mr. Campbell?
Indeed it is, yes.
Yep. And then we have Miss Crosswaite, who will be represented by Dr. Connor. And then the applicant represented by Mr. MacLeod and Mr. Robb. Is that correct, Mr. Ennis?
Yes, and it's just to probably explain that, Madam, the reason why I can't attend quite a lot of these things is I've got another hearing that's a process that started back in October, and dates have changed, and therefore I'm certainly not available for certain parts of the subsequent process. And rather than seeking to delay the matters, I've arranged for Mr. MacLeod to deal with the hydrology session on next week, and Mr. Malcolm Thompson will be dealing with the matters in the first week of February and the second week of February. I may be available for the hearing session on conditions. I potentially have availability for that and have been involved in that, so I may well attend that. But it's the fact that I've got potential clashes meaning that I really can't. I can't just rely on those going away. So we've made alternative arrangements to enable to keep to the commitments regarding the timetable that has now been set for some time. So it's unfortunate, but we've managed to resource it, and we'll deal with it in that way.
Okay, well, thank you for that, because you know, it was difficult for us to get our dates in place. So it's good that you've been able to find alternatives to step in for you. Now, I anticipate that when it comes to the applicant's evidence, Mr. Campbell will cross-examine first, followed by Dr. Connor. Is that okay in terms of?
Yes, ma'am, that's okay. Well, sorry, I haven't asked Dr. Connor, but
she's put her thumbs up, so she's fine with that.
I think the council will go first in a situation like that.
Yep, and please remember that advance notice of the documents for the inquiry on hydrology and private water supply should be circulated by 5 PM tomorrow, Tuesday. Any questions on procedures for the inquiry? I mean, for those of you who aren't taking part in this week's, might be, you know, helpful if you get a chance to dip in and have a look at how it's going, because obviously that will prepare you for the landscape and visual and noise inquiries as well. So, any other preliminary matters that anybody would like to raise today? No, everybody fine. So if not, I'll conclude proceedings for today. Thank you all for your attendance, and we'll see some of you tomorrow at 10 AM.
Thank you.
Thanks very much.
Thank you, ma'am.
Bye-bye.
Thank you, everyone.
Thank you.